Companies Amendment Bill 2014, second stage. And I call on Deputy Stephen S. Donnelly to move the second reading motion, namely that the bill be now read a second time.
I so move.
Thank you. It's 40 minutes in this time slot.
Thank you. And I'm sharing my time with Deputies McGrath and Murphy. Last Ceann Comhairle. Thank you. Last Ceann Comhairle, I'm delighted to have the opportunity to introduce this bill for second stage this evening. And I'd like to thank Ross McGuire, SC, and Solicitor Barry Lyons for all of the work and the expertise that they have provided in drafting this bill. I'd like to thank very much the officials of the Oireachtas Bills Office for their Trojan work in helping me and the team last week in getting the bill ready. I'd like to thank Minister Bruton and his officials for their time and expertise over the recent weeks. And finally, last Ceann Comhairle, I'd like to thank in advance my fellow deputies who will be contributing to this debate today and tomorrow for the time and the effort that they are putting in. The Companies Amendment Act 2014 seeks to radically improve Ireland's examinership process. It reduces the costs and bureaucracy of examinership. It reduces the refinancing requirements of examinership. It addresses the legacy issue of upward-only rents. In doing all of this, it makes examinership a real option for the first time in Ireland for viable but insolvent small and medium-sized enterprises. If this bill is passed, it has the potential to save thousands of companies in this country and to save tens of thousands of jobs in the coming years. And last Ceann Comhairle, this is not wishful thinking. The solicitor I worked with in preparing this bill has handled over half of all examinerships in Ireland in the past 12 years. The senior counsel I worked with in preparing the bill has a significant experience in insolvency law. The process described in this bill and the changes it seeks to make specifically address what is not working in examinership today and propose a better solution. With that said, last Ceann Comhairle, I'm not presenting this bill as a finished article. I've no doubt it can be improved through the legislative process. If the Minister believes that there are constitutional issues to be teased out, then let's do that, and let's do it through the legislative process. If this bill is accepted by government at second stage tomorrow night, then we have a structure and we have momentum to turn the examinership process in Ireland into something that provides a second chance to viable businesses all over the country. Last Ceann Comhairle, examinership is a complicated process, so I'd like to use a real-life example to illustrate both the problem and the opportunity that this bill addresses. I met recently with the owner of a family-run business in Wicklow. Now, this company manufactures for both the domestic and the international markets. Its exports have been growing steadily over the past few years, and it's been particularly successful exporting into the UK. The company employs about 20 people, and as it grows, it's continuing to hire more people. The company is profitable, but critically, the company is insolvent. Now, in the case of this particular company, here's why. One creditor in the UK who bought and received a large quantity of product went into liquidation. So this company, this profitable, growing, export-oriented company, finds itself with a large hole in its profits and loss account, and it cannot continue to cover all of its costs. In short, it's insolvent. So, what options are available to this company, last Ceann Comhairle? The first is that it can enter voluntary liquidation. Now, what happens in this case? In this case, the company is shut down, the staff are made redundant, the assets would be sold, and the creditors would be paid some percentage of what they're owed. In short, everybody would lose. The staff would lose their jobs, the families of those staff would lose their household income, the shareholders would lose their company, the creditors would only get paid a fraction of what they're owed, the other companies that this company works with would lose a valuable customer, and the state would lose corporation tax, income tax, VAT, and would have 20 more people out of work to support. So that's the first option. The second option for the company is courts liquidation. Now, in this case, the creditors would apply to the courts for a forced liquidation. And this would have all of the same downsides as a voluntary liquidation. with the additional downside of heavy legal costs for all parties involved. So again, everyone would lose. In this case, they'd all lose a bit more, and a few lawyers would win a little bit. The third option for this company is receivership. Now, in this case, the creditors would appoint receivers to their secured assets. For this particular company, those secured assets are mainly machinery, vehicles, and premises. The assets would be sold off, almost certainly at a loss to the creditors. And of course, without these assets, the company wouldn't be able to trade, bringing us back to the same destructive outcome as voluntary or forced liquidation. The fourth option available to the company is examinership. Now, here's how examinership is meant to work in the country right now. First of all, an independent accountant would be retained, and he or she would review the company's finances and give an opinion on the viability of the company. In this case, in the case of this business in Wicklow, the accountant would almost certainly conclude, I haven't seen the books, but based on what I've been told, that the company is viable and the debts should be restructured, and that this company is a good candidate for examinership. So an examiner would be hired, they'd prepare a court petition seeking examinership protection, and they would file those papers with the courts. Previously, they would have been filed with the High Court, and then following the bill that the Minister passed in December, they'd now be filed with the Circuit Court. So, once the papers are filed, the examinership would be advertised. The creditors would find out that there's an examinership process going on, and they'd all come to court. So the company directors, the creditors, their lawyers would all appear in court, and the judge would decide whether or not to award protection to this company in this case. Now, in the case of the company we're talking about, I'm pretty sure that the judge would award protection because it would be an obvious candidate for the examinership process. So what happens then? The courts then give the examiner 70 days to meet with all of the interested parties, to prepare a survival plan, to get that plan agreed with all of the creditors, and critically, and very difficultly, certainly in these circumstances, to find new investors to refinance the company post-examinership. This can take several trips to court, as any of the parties might dispute various aspects of the process. After all of this, if the examiner is successful, all of the parties would return to court for another hearing, at which the agreed plan would hopefully be agreed by the court, be agreed by the judge, and receive court approval. So what's the outcome of this process? The company continues to trade, the employees keep their jobs, and more are hired as the business continues to grow. The companies that trade with this company retain a valuable customer. The creditors get back at least as much as they would have through a liquidation or receivership process, and of course the state continues to receive taxes. So this is a real case in Wicklow. This company has 4 potential futures. In 3 of those futures, everybody loses. And in the 4th, which is examinership, everybody either wins or is no less worse off than they would be in any of the other 3 futures. Now, given all of this, you'd expect that this profitable, family-owned, export-oriented company would come through the examinership process and continue to trade. But as the examinership process works under law today, the chances are it won't. There's every chance that the company I'm describing is going to end up being forced to close. And this isn't an isolated case. In the last 3 years in Ireland, there have been about 4,700 insolvencies. There have been just 64 examinerships. So there's been 1 examinership for every 73 insolvencies. And the reason there have been so few examinerships relative to the high number of insolvencies, of course, and I think we both agree, Minister, the examinership process doesn't work. It's completely unfit for purpose in this country. So I'd like to outline five main reasons why the current process doesn't work. The first is that it's too expensive. The people I prepared the bill with estimate that an examinership at the moment costs about €70,000 and can be as high as €350,000. And most of this, as we know, is for legal fees due to multiple court appearances. And I would like to commend the Minister in his bill from December, which brought the examinership process from the High Court to the Circuit Court. Based on the contributions made by the Minister at the time, my understanding is the main reason for this is to drive down the costs. I voted for the bill, I support the bill, and I welcome the move by the Minister. So, the first reason why examinership doesn't work is it's too expensive. The second reason it doesn't work is it's open to abuse by creditors. Now, I'm told that in some examinerships, creditors find ways of forcing proceedings into the court, back into the court, again and again and again. Now, I'm told they do this in order to make the examinership process so expensive for the company that the directors are simply forced to abandon the process. The third reason the examinership process doesn't work is that the refinancing costs can be too high. Now, many banks, as we know, have so-called on-demand clauses in their loans to SMEs. Therefore, during the examinership, they can insist on full repayment against their secured asset. Now, in today's credit-constrained world, the companies can't find the level of finance needed, and so, again, the process can fail. Fourth reason the examinership process, as constituted today, fails is that landlords are refusing to budge on upward-only rent. Not in all cases, but certainly the people who are doing this on the ground are telling me that some landlords are refusing to budge from the artificially high rent, the bubble-era rents, even though they know that it means that the company in question will be liquidated. Fifth reason the examinership process doesn't work in Ireland is that in some cases essential creditors refuse to trade without guarantees. So let's take the example of a restaurant. Food suppliers may not provide the restaurant with any produce during the examinership process because they're not secured creditors. Because they say, look, we're going to sell you the fruit, we're going to sell you the veg, we're going to sell you the meat, but we know you're in examinership, and we know that if there's any money to be divvied out, we're at the bottom of the pile, so we're not going to do it. And in this case, again, the examinership process fails because the company can't continue to trade. It's the combination of these 5 problems, and undoubtedly many more, that mean that examinership in Ireland isn't working for SMEs. And because of that, viable companies are being shut down all over the country, and jobs are being lost that shouldn't be lost. As I said, in the last 3 years, there were about 4,700 insolvencies in the country. Now, it's hard to estimate how many of them could go through a functioning examinership process. But if we're conservative and say 1 in 5, so 1 in 5 of the companies that were deemed insolvent go through examinership, then over the last 3 years, nearly 1,000 companies would have been saved that no longer exist. And it's entirely possible that the potential prize is in fact much bigger. There's about 15,000 SMEs in Ireland. Now, sadly, that's down by about 2,000 since the start of the crisis. But still, these 15,000 SMEs account for 70% of the workforce in this country, according to the Department of Finance, and, astoundingly, constitute 99% of all companies operating in the Republic. So it's an understatement. We hear it all the time. I hear the Minister say it. I've no doubt I say it, that SMEs are the backbone of this economy. But if 70% of the workforce works in them, and they constitute 99% of the companies in this country, then it's worth repeating that saving these companies and helping this sector is helping the backbone of the economy. However, they urgently need a functioning examinership process. Just a few weeks ago, in December, the central bank reported that up to half of the total amount loaned out to SMEs could be in trouble. There's about 50 billion lent out to SMEs in Ireland at the moment. So we could be talking about 25 billion in loans to the SME sector that are currently in trouble. And at the same time, we know that Irish businesses are finding it hard to raise credit. Now, some of the banks disagree, and maybe in some cases they're right. But a recent ECB survey shows that Irish SMEs are facing significantly tougher credit conditions than in the Eurozone average. So the ECB is saying it is harder for the SMEs to get credit here than it is for SMEs on average to get credit in the Eurozone. So what's the likely result of this? The central bank says half of the loans could be in trouble. The ECB says it's harder for your SMEs to refinance. So the likely result is that many more SMEs are going to close down this year, next year, the following year, that don't need to close down. Viable SMEs that have had a shock to their profit and loss, maybe partly their own fault, maybe entirely somebody else's fault. And that's going to happen because the examinership process doesn't work. It's not fit for process. This is why I've introduced this bill. This is the first private member's slot I've had, I think on my own, I'm pretty sure, since this Dáil term started nearly 3 years ago. I've chosen to introduce the examinership bill in that slot because I absolutely believe that if we get this process right, thousands of companies will continue to trade that otherwise would close down, and tens of thousands of jobs will continue to exist that otherwise wouldn't. The bill radically reduces the cost of examinership. Now, our best estimate is that it will reduce the average from 70,000 to 20,000 euro. It does this by removing the necessity for all parties to appear in court on multiple occasions, hence obviously lowering the legal fees. There is still full court oversight. Any party can still bring proceedings to court at any stage if they wish, and there is still final court authority. The final examinership agreement must still receive court approval. The bill makes it more difficult for vexatious or frivolous court involvement. If a judge deems a creditor to be involving the court for vexatious reasons, legal costs can be awarded against that creditor. Now, this makes it much more difficult for a powerful creditor to bully viable businesses out of the examinership process. The bill allows the court to impose lending conditions on secured lenders over 5 years. This is important. It means that a bank cannot simply activate the on-demand clause and shut down a viable business. The bank still does well, however. It retains its security, it's paid 7% per year interest on that security, and after the 5 years, it can call on the security. The bill allows the court to change upward-only rent contracts. In this case, the rent is adjusted to market rates plus 7% for 5 years. Now, we're told that the government sought opinion on upward-only rent agreements in 2011 and was told that there might be constitutional issues and therefore didn't try and legislate for them. The case of examinership, however, is different. Should the company be shut down, the landlord would, in the future, receive market-level rent from the next tenant, and of course will incur the costs of trying to find a tenant and get rid of the existing tenant. Under examinership, they would receive 7% higher than the market rate, and of course they wouldn't incur any of the costs of securing a new tenant. As such, the landlord has not only not been unfairly prejudiced, the landlord's property rights have not been affected, they've actually been improved based on what would have happened through a receivership or a liquidation process. And finally, the bill allows the examiner to give priority to certain essential creditors. If we go back to the example of a restaurant, the bill would allow the examiner, with the approval and authority of the court, to give the same level of protection to the company supplying the food as it gives to the bank. And this means that essential but unsecured creditors would continue to trade with the company, meaning the company could continue to trade. The Minister, I've discussed this bill with the Small Firms Association and they support it. They mentioned that they've been trying for years to get the examinership process changed and that the changes in this bill would work very well. I've discussed the bill with the Dublin Chamber of Commerce and this is what they said. The ultimate aim of examinership is to allow the business to survive and recover. It's important that politicians ensure that legal hurdles to enter the examinership process are in proportion to the size of a business. Making sure the process moves as fast as possible will reduce costs for SMEs, leading to more businesses escaping a situation in which all parties would otherwise lose out. This bill achieves all of those goals. Minister, the SME sector in Ireland deserves and needs the Oireachtas to support it. And this bill does that. It could save thousands of businesses and tens of thousands of jobs. And it could do that without a single cent of investment of public money. And if you, Minister, and the government accept this bill at second stage tomorrow night, then we could start seeing the benefit of that very, very soon indeed. Finally, I would say this. It's a political point rather than a examinership point. Government ministers regularly criticise the opposition, not unreasonably, I think, in many cases, for not proposing ways out of this crisis and for not coming up with solutions. This bill is a solution. It's a really, really good solution. It will save businesses, it will save jobs, and it doesn't require any investment of public money. So the question for the government is not, in this case, whether or not members of the opposition propose solutions. The question is whether or not the government is willing to accept those solutions when members of the opposition propose them.
Thank you, Deputy.
I commend the bill to the House.